So hello everyone and welcome again to dispute resolution. Today's topic is arbitration. So let's begin with what an arbitration, how it looks, what it does, how it's different than negotiation, mediation. We'll take a look right now.
Arbitration, much like mediation or negotiation, is a method of alternative dispute resolution, which goes by the acronym ADR. ADR methods represent alternatives to traditional litigation. Thus, instead of a case being tried in state or federal court, parties agree to have it arbitrated. To better understand how arbitration works, we need to compare arbitration to litigation and the other ADR methods. First, we'll begin with a negotiation. A negotiation is generally informal and involves a series of offers and counteroffers between the parties until they reach an agreement to resolve their dispute. It is by definition a voluntary process, and it may or may not ultimately resolve the dispute. A mediation is typically a voluntary process, though it can be required by a court. In a mediation, a third person, referred to as the mediator, tries to assist the parties in resolving their dispute. Oftentimes, a trial court judge will even order the parties to undertake mediation. The mediator's role is to help the parties reach an agreement and thus to resolve the case. The mediator can suggest the terms under which the parties should settle the case. However, the mediator lacks the authority to require the parties to settle their dispute or to dictate terms. Litigation is a lawsuit, which could result in the case being settled by motion or by trial, with or without a jury. The United States Constitution guarantees a right to trial by jury in many civil cases at the demand of either party. Should a jury make a bad decision, the trial court judge has an obligation to correct the jury's verdict. This could result in the jury's verdict being dismissed, reduced, or even increased. If the trial court judge fails to correctly apply the law, an appeal can be filed. Now we'll approach arbitration, which is an alternative to these three methods of settling a dispute. Unlike mediations or negotiations, arbitrations are binding on the parties. They are binding in at least two ways. First, the arbitrator's ruling resolves the dispute, even if one or both parties do not agree with it. Second, an arbitrator's ruling will likely prevent any meaningful appeal or modification by a trial or appellate court. Arbitrations can run the whole gamut of dispute resolution. For example, they can resolve disputes between two large sophisticated businesses, two or more insurance companies, a dispute between a large corporation and a consumer, and even disputes between two or more individuals. Under federal law, arbitration is both permitted and even encouraged, as evidenced by the Federal Arbitration Act. Under this law, disputing parties agree to waive their rights to a trial. This is commonly done before the parties even realize that there is a dispute. Such an agreement is referred to as a pre-dispute arbitration agreement. These are common in contracts that are negotiated and signed at the outset of a business relationship. Examples of such agreements can be found in mortgages and in contracts for credit cards, cable television, or even that cell phone that you're using. It's almost impossible to buy a new automobile or have a loved one admitted to a nursing home without signing an agreement that contains an arbitration clause. If an authorized individual signed the agreement, it is most likely binding. Arbitration can avoid the time and expense associated with litigating a dispute. Instead, one person or a panel reaches the conclusion in the case. The arbitrator acts as a substitute for the trial court judge, the jury, and even the appellate court. The arbitrator's decision is final, and it is unlikely to be reversed or modified on appeal. Sometimes a three-arbitrator panel judges a case. One popular method of appointment is having each party select one of the arbitrators. The two arbitrators then select the third arbitrator. Unless there is an agreement to the contrary, a unanimous decision by the arbitration panel is not required. A majority vote is sufficient. Virtually all arbitration agreements identify a forum. This is the organization that established the parameters of the arbitration, such as who can serve as an arbitrator, who is responsible for paying for the arbitration, limitations on discovery, and whether the parties can request an evidentiary hearing. One of the most common arbitral forums is the American Arbitration Association. The arbitral forum will typically have a list of approved neutrals. These are the people who are permitted by the forum to serve as arbitrators. An arbitrator may agree to arbitrate a dispute for a set fee, although arbitrators typically charge by the hour for their time. Most approved arbitrators are either retired judges or experienced attorneys. However, some organizations, such as the Better Business Bureau, prefer local professionals who are familiar with a subject matter, such as a structural engineer, for a dispute involving the construction of a house. Unless otherwise specified in the arbitration agreement or the arbitral forum's rules, it typically is understood that the resulting cost of the arbitration will be split equally between the parties. However, many arbitration agreements require that the party who is seeking to enforce the agreement pay for the cost of the arbitration. The scope of discovery is more limited in an arbitration proceeding than in a civil action. If the matter was litigated, it is likely that the applicable rules of civil procedure would govern the various forms of discovery available, including interrogatories, requests for production of documents, depositions, and subpoenas to compel individuals to either testify or produce documents. Instead, the arbitrator will follow the rules of the arbitral forum. The arbitral forum will have rules that address the number of depositions that can be taken, the number of document requests that can be made, and the number of interrogatories that can be propounded. It can also specify the number of witnesses who can testify at the hearing. Some arbitration proceedings are simply a matter of the parties submitting position statements and supporting documents to the arbitrator, who then reviews them and issues a ruling or decision. This is common in disputes between insurance companies, in which they are each trying to determine which of their insureds caused a wreck. Other arbitration proceedings result in hearings before the arbitrators or arbitration panels. The procedures established by the arbitral forum will dictate what is permitted into evidence, how long the hearing can last, and whether the parties will be permitted to make opening statements or closing arguments. The arbitrators are the triers of fact. As there are no juries in arbitration proceedings, the authority of the arbitrator to issue subpoenas to require people to attend the hearing, or for third parties or for entities or individuals not parties to the dispute to produce documents, is also quite limited. Though its costs may pale in comparison to lawsuits, arbitration can be a very expensive method of ADR. In addition to each arbitrator charging for his or her time, arbitration forum will charge various administrative fees. Oftentimes, the fees are based on the amount in dispute and the number of parties to the arbitration. An arbitrator typically has no authority to enforce his or her decision. Therefore, it may be necessary for the prevailing party to file a lawsuit to enforce the arbitrator's award. If the arbitration took place because one of the parties to a pending lawsuit filed a motion to compel arbitration that a trial court granted, the prevailing party to the arbitration can simply file a motion with the trial court to enforce the arbitration decision. Otherwise, a separate lawsuit to get a judgment to enforce an award will be necessary. As previously addressed, rarely is an arbitrator's decision ever vacated or overturned by a court. This is true even if the arbitrator incorrectly interpreted the facts or misapplied the applicable substantive law. An arbitration can be a faster and more cost-effective method of dispute resolution. It has its shortcomings, but as this presentation demonstrates, it has also numerous practical advantages over other types of ADR and even litigation.
Okay, so that just kind of gives you an idea of overview of why arbitration and what it is and why it's important. So what we'll do is we'll kind of take a little bit of a deeper dive into it. We'll definitely look at some clauses that you might readily sign and see what things typically look like. We'll look at the rules. Again, now the rules, there are various organizations. The most famous is the American Arbitration Association, but there's also the National Arbitration Association, and they have their own set of rules. And the parties can come up with their own rules, right? So they do that, via contract. So let's talk about the types of arbitration, right? So there's really kind of two types when we think about how parties get to arbitration, right? Now, there is private arbitration, and this is the process chosen by the parties outside of the court system, right? So they're like, well, we don't want to go to court, we'll just do a private arbitration. And most of the time, this is how the arbitration will go. This is how most arbitrations take place. But parties, as the video referenced, can be compelled to have what's called a court-annexed arbitration. And what it does is it takes place in a courthouse by the arbitrators provided by the court system or under the court's authority. Right, so in New York, they have lemon law arbitration. Right, so the car's a lemon, it means that it was out of service for a certain number of days, and you or took it to the mechanic 3 or more times within a certain period of buying the car. And under lemon law, you can get your money back. And the car has to be deemed a lemon and has to be recorded as such, and so on and so forth. It is subject to court-annexed arbitration. So what you do is you file the case, but the case goes to the arbitration association. They choose the arbitrator. The arbitrator then conducts the hearing. So that's kind of how that works in New York. Small claims court, that's very similar. The parties can, if they want to go to arbitration, they can. Usually it's more of a mediation style model, but lemon law is definitely arbitration. Now there's two types of subtypes of these, right? So there's binding arbitration and non-binding arbitration. So most of the time we're going to have binding arbitration, right? And in this case, it's the arbitrator's award is final and generally not appealable, right? So as the video demonstrated, even if the arbitrator gets the facts wrong or the arbitrator misapplies the law, that's the risk that you take going to arbitration, right? You kind of inherently take it. Now, what's very rare, but it does happen and it does have some value, is non-binding arbitration. So the parties are notified after initial party or pleadings are filed with the court to appear before an arbitrator to present their case. If the parties are satisfied, then it becomes a judgment within that specified period of time. Right, so if both parties they file a court and both parties are happy with what the arbitrator comes out with, then the court case ends, right? And that's what they do. If either party is dissatisfied, all they have to do is notify the court, and then the court will have what's called a trial de novo of the matter. And de novo just means anew. So basically a brand new trial where we don't even consider the arbitrator or what the arbitrator said or anything that has to do with the arbitrator. We're just going into traditional litigation, right? So non-binding arbitration can be okay if the parties have a good working relationship. And again, it's substantially cheaper. It's not cheap, but it's still substantially cheaper than going to traditional litigation. But if the parties don't come out with anything from the arbitration, then they have a full trial, right, that they are entitled to. And the arbitration and arbitrator, anything said there stays there. It cannot be brought into court. So what I want to take a look at just for a couple of minutes were the types of clauses, right? So as I said, when we're talking about arbitration, most of the time it's private arbitration and it's binding arbitration, right? So theoretically, whether arbitration is mandatory or voluntary determines whether the parties are required to participate in arbitration or choose to do so. So if we take a look at, and this is a sample clause that would go into a contract for a commercial dispute, commercial clause, right? You would read a contract and they'll be in depending on the state, it might have to be capitalized and bold. Sometimes it can just be, you can't put it in fine print because you are giving up a constitutional right. right? So commercial dispute might say any controversy or claim arising out of or relating out of this contract or the breach thereof shall be settled by the arbitration administered by the American Arbitration Association in accordance with its commercial or other arbitration rules, and judgment on the award rendered by the arbitrators may be entered in any court having jurisdiction thereof. So what does that mean in legalese? That means you have some kind of problem under this contract or you think I've broken it, you don't get to go to court. We have to go to arbitration, and we are going to go to the American Arbitration Association to arbitrate our process, and they are going to use the commercial arbitration rules. So what do the commercial arbitration rules look like? I will show you. So if this is the American Arbitration Association website, right? They have all kinds of different practice areas that they kind of specialize in. But what they have is they have a set of rules for every dispute that they deal with, right? So the first thing that we were looking at was the commercial arbitration rules and mediation procedures, because we were talking about a commercial clause, right? So here you can find the rules, the forms, and the fees associated with an arbitration arising out of a commercial dispute. Now, if you click on something like the rules, it'll take you to this lovely paper, right? This is a 46-page document detailing the rules and procedures for commercial litigation, right? And it gives you, let's see, how many rules are there? 58 rules, preliminary hearing procedures, expedited procedures, procedures for large commercial disputes, administrative fee schedule, commercial mediation procedures, et cetera, et cetera. But what it does, if you look at like our commercial arbitration rules, it says filing requirements, answer fair limits jurisdiction, mediation might be a part of it, appointment from a national roster, appointment by a party, nationality of the arbitrator, number of arbitrators. All right, so let's try that. Let's go down and look at that. Rule 16, number of arbitrators. So that's on page 17. And these are all the rules that you have to abide by during the arbitration, right? So just like there's steps that you have to abide by in court, you also have to abide by these steps in arbitration. So we'll look at number of arbitrators. A says if the arbitration agreement does not specify the number of arbitrators, which our clause did not, the dispute shall be heard and determined by one arbitrator, unless the American Arbitration Association, AAA, in its discretion directs that 3 arbitrators be appointed. A party may request 3 arbitrators in the demand or answer, which the AAA will consider in exercising its discretion regarding the number of arbitrators appointed to the dispute. Moving on to B, any request for a change in the number of arbitrators shall result as a result of an increase or decrease in the amount of a claim, or a new and different claim must be made to the American Arbitration Association and the other parties to the arbitrator no later than 7 calendar days after their receipt of the Rule 6 required notice of change of claim amount. Parties are able to agree, yada, 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 right? So what this basically tells us is, okay, by that little agreement that's saying that you're going to abide by the rules of the AAA, specifically their commercial rules, you are agreeing that, well, we didn't set the number of arbitrators, so we are going to default to 1, right? Unless the AAA or another party asks for more than 1, so 3 arbitrators. And even in that case, it's really up to the AAA to decide whether or not they're going to have a certain number of arbitrators. Right, so that's for commercial purposes. If we look right? It's a very simple, small clause, but it changes your rights, right? So basically, you are forgoing your constitutional right to have a trial by jury, and instead are going to have some person, hopefully an expert in your field, but not necessarily, decide the case. And how are they going to decide it? They're going to decide it by applying the arbitration rules that you agreed to. In this case, the AAA's commercial arbitration rules. Similarly, we have employment, right? Employment contracts. These employment agreements occur a lot, right? So any controversy or claim arising out of or relating to this employment application, employment ADR program, employment contract, you choose one of those, shall be settled by arbitration administered by the American Arbitration Association and under its employment arbitration rules and mediation. Judgment upon the award rendered by the arbitrators may be entered in any court having jurisdiction thereof. Right, so it's very similar to the commercial clause, but instead we're saying, instead of using the commercial rules, we are going to use the employment rules, right? So if we scroll down, here's employment arbitration rules and mediation procedures. So again, we can click on the rules link, see that this one is only 36 pages long. And again, we can look and see that here are all the rules and the procedures that you have to abide by. 48 in this one. Optional rules for emergency measures. So if there's emergency costs, and then mediation procedures. So let's say we want to look at number of qualifications and appointments of neutral arbitrators, right? So we kind of looked at the arbitrators last time. Let's look at the arbitrators requirements this time. So we scroll down to 15, and 15 tells us, here's this long list of who qualifies as an arbitrator, right? So if the arbitration agreement does not specify the number of arbitrators or the parties do not agree otherwise, the dispute shall be heard and determined by one arbitrator, right? So again, this kind of takes it out of, yeah, well, the AAA might decide more. No, this says, unless they agree, it's one. The qualifications, they have to be a neutral arbitrator serving under these rules, shall be experienced in the field of employment law. Neutral arbitrators under these rules shall have no personal or financial interest resulting in the proceedings, yada, yada, yada. Right, so in this case, unlike the commercial case, we didn't require somebody to have experience, right, with the particular issue. In employment, the AAA says you need somebody who has experience in employment law. Now, this is a completely optional thing. So this isn't like a hard set fast rule. If it's an employment case and the parties decide not to use the AAA employment schedule, then they can go back and use whatever place or whatever organization they want, use their rules or come up with their own. Now again, this is enforceable in court once the award has been made. Now, this is what I'm going to give to you all. So I pulled up Apple's arbitration clause, right? It's interesting, and we'll talk about why, and I'll show you why it's a very interesting clause in a moment. But this is specifically related to Apple Pay, right? So what this says, and this is the contract that you sign when you sign up for Apple Pay, you and Apple Pay mutually agree that any dispute, claim, or controversy, whether based on contract, tort, statute, fraud, misrepresentation, or any other legal theory, arising out of or relating to these direct payment terms, or the breach, termination, enforcement, interpretation, or validity thereof, including the determination of the scope or applicability of this agreement to the arbitration, or to the use of the direct payment services hereinafter claim or claims shall be settled by binding arbitration before a single arbitrator. So that was a bunch of legalese saying, if you have a problem with something that's related to Apple Pay, you have to go through arbitration, and it will be before a single arbitrator. Right? But I thought you'd like to see what the actual clause looks like that you sign. So if I remember right, it's down here is 13, right? So this is really, really important. You'll see arbitration notice. You can look at the differences here. Right? So most stuff is just lowercase, just plain language disclaimers. They're in full caps. Arbitration is in full caps and bold, right? And it notes that the direct payment services is being made available and priced by Apple Payments on the basis of your acceptance of the following arbitration notice. By entering into this direct payment terms, you are agreeing to binding arbitration rather than litigation in any court. You hereby knowingly and voluntarily waive the right to assert any claim arising out of or in connection with the direct payment terms in any court except expressly provided below in section 13C. You further acknowledge that you are entering into these direct payment terms voluntarily and not in reliance on any promise or representations whatsoever except those contained in these direct payment terms themselves. This arbitration notice affects your legal rights. Please read it carefully. Right, so and this will be something that and anytime you have an update on your phone, Apple update or Samsung update, you re-agree to these terms. Like nobody reads them. I mean, nobody reads them. That's why they put them in bold and all caps, because you're giving up a constitutional right. That being said, still nobody really reads them. And it's just, okay, download the latest update, whatever it is. So what I want to show you is what this actually looks like in real life here. There we go. All right. So this is the arbitration notice. Like I said, it's in bold, it's in all caps, and it does discuss that your legal rights. Please read it carefully. And then this is where we pull just a portion, right? Just a portion of the arbitration claims, right? And in this case, instead of being administered by the AAA, it's administered by JAMS, right? And it's governed by their rules. Any claim will be decided by an arbitrator rather than a judge or jury. An arbitration award will be final, binding on you and Apple Payments, without any right of appeal. Court review of an arbitration award would be very limited, with the exception of Section C below. You and Apple Payments hereby waive the right to assert any claim in any court, as set out in Section D below. All arbitrations will be conducted on an individual basis, and there shall be no class or collective actions in arbitration. So what it does then, it moves us down and it lays out exactly in what cases can you bring, what are the rules, what are the limitations. So individual claims, a claim is going to be submitted to arbitration on an individual basis only. Claims subject to this arbitration provision are not to be joined or consolidated in arbitration with any claim of any other person or arbitrated in a class basis. In representative capacity on behalf of your general public or on behalf of another person unless otherwise agreed to by the parties in writing. And then again, you acknowledge and agree you are waiving any ability to join or consolidate your claim in arbitration with a claim of that of any other blah, 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 blah. Right? So it's restating what it's saying, but this time we're putting it in bold because the idea is, well, we know people don't read them. You should read them. If nothing else, read the bold capital parts, right? Those are the ones that really affect you. This one talks about arbitration fee, and that one, again, as the video mentioned, usually it's a split between the parties evenly. Some larger corporations will pay the fee themselves. right? Because the fee is usually fairly cheap. If it's just a simple customer versus the company dispute. So arbitration fees. If you initiate arbitration, Apple Payments will advance any arbitration fees, including any required deposit. Apple Payments will also be responsible for payment and or reimbursement of any arbitration fees which exceed either one, the amount of the filing fees that you would have incurred if your claim had been brought in a state or federal court nearest your residence or jurisdiction, or two, $250, whichever is less. If Apple Payment initiates or elects arbitration, Apple Payments will pay the entire amount of the arbitration fee, including any required deposits. Regardless of who initiates arbitration, Apple Payments will pay the arbitration-related costs, including any remaining JAMS case management fees and all professional fees associated with the arbitrator's service. Right? So what this basically says is, more or less, look, you have a problem with us, like, we'll pay for the arbitration because they don't want to go to court. So we'll pay for the arbitration and just go from there. Right? So they're not necessarily agreeing to split it evenly. They are agreeing to take it on themselves, taking that burden off the consumer. Now, this is important because contracts can be written in such a way that they are deemed what's called unconscionable. Right? An unconscionable contract is one that a rational person would not enter into under a normal basis. Right? So you give up your constitutional rights, and if Apple Payment said, oh, in addition to giving up your constitutional rights, you also have to pay the full amount of the arbitration, which can be thousands and thousands of dollars. Right? That stifles you. Like, you're not going to file a claim because maybe you don't have the money to file a claim. Right? Here we're saying, to make it sure, and if that was the case, that you had to pay in addition to giving up your rights, courts are going to look at that and go, you know what, that doesn't seem fair. That doesn't seem right. That's unconscionable. And so a court can strike down an arbitration clause. But Apple got around this by saying, we'll pay in advance the arbitration fees and any deposit. So the idea here is, you're giving up your rights, but Apple, we will pay for the arbitrator and the arbitration services. Right? So it kind of is a give and take. You'll see section F deals with arbitration procedure. Right? It talks about how many days you have. The arbitrator's award will address all claims properly, blah, 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 blah. Confidentiality and severability. And it moves to changing in terms, governing law, and effective date. So this whole thing is, let's see, there. This whole thing is an arbitration clause, or clauses. It's an arbitration agreement. And it will be found if you use Apple Pay, like, you're bound to it. If you use an iPhone, you're bound to something very, very similar worded. This is how if you say, I'm going to sue Apple because my phone stopped working, you're like, no, that's not how that's going to work. Right? Like, you have to go through, because if you file in court, you've already agreed to arbitration. So if you file in court and you say, oh, I'm suing them because my phone didn't work, it wasn't worth the money, or whatever it was, what Apple is going to do, Apple is going to file a motion to dismiss or a motion to compel arbitration, right? Because you've already agreed that you're going to arbitrate this. And so the court's going to say, look, you agreed to arbitrate it. You could have not agreed to arbitrate it. Theoretically, these are supposed to be negotiable. They're not. They're called what they're called is contracts of adhesion. Basically, it's a take it or leave it, right? Like, you don't get to negotiate. You don't get to call Apple and say, I don't really like this term. Can we talk about? No, they're not going to do that. It's going to be like, you buy the phone, you agree, or you don't buy the phone because you don't agree. Like, that is it. And again, courts aren't too fond of contracts of adhesion, but we understand there are millions and millions and millions of purchases made every day. We understand that contracts of adhesion are pretty much central to the easy flow of goods. So again, this is just the consumer clause. Now, as an arbitrator, right? Again, whether this is a panel, so whether this is a 3-person panel or 2-person panel or 1-person panel, an arbitrator has to conduct an efficient and bias-free hearing pursuant to either the contract, so whatever the contract says, or the statute. So if we're under federal law, we have to follow the Federal Arbitration Act, and makes a fair and independent award based upon the contract or the law. Now, that being said, this award has to be written, and it has to include reasons for the decision. Now, theoretically, this is a place where that you get grounds for an appeal. But recall, you waive appeals, right? And even in the Apple agreement, you waived your right to appeal. That's true up until a point, right? Up until it crosses a state statute or it crosses a federal statute. So if you issue a written award and you've included reasons for your decision, and your reasons violate federal law or state law dealing with arbitrations or dealing with, and not necessarily the subject matter itself, but dealing with arbitrations, then you might get your decision overturned or at least reviewed. Right? You also have to avoid any conflicts of interest. This is actually becoming increasingly more difficult as the world as we become more globalized, right? So think about, let's say you get into a dispute with Apple, and Apple appoints, or JAMS appoints a single arbitrator, right? Because your phone isn't working and you want to take down Apple. And the arbitrator sits down, right, kind of like at a judge's place, and pulls out of his pocket his iPhone and sets it on the table. Is that a conflict of interest? Right? This person owns an iPhone. Could it sway them one way or another? Yeah. Do they have any real interest in the outcome? Maybe, but probably not. And we also realize that, look, most people have either iPhones or Samsung. If we just said, if you have a cell phone like this, you can't arbitrate, it would be near impossible to make things run efficiently. And so conflicts of interest, what we're really looking for is, do you stand to benefit? Do you stand to gain anything from this arbitration? Do you know one of the parties? Right? Have you worked with one of the parties? This is with contracts, commercial disputes a lot, right? Is especially construction contracts. You will have basically construction. You hire a contractor, right? That contractor is called a general contractor. And what he does is he might render some services, but what he does is he hires subcontractors to do everything else. So he'll hire a subcontractor to do the foundation of a house. He'll hire a subcontractor to do the framing of a house, et cetera, et cetera, et cetera. And so you can have definitely multiple people. And the idea here is you don't want to say, oh, get into that room and say, oh, hey, Bill, yeah, you worked on my house before. That's a conflict of interest, right? Because either you are for Bill or against Bill. Like you have some kind of predetermined, preconceived notion walking in, and you can't do that. In addition, you must maintain confidentiality. So just like mediations are confidential, arbitrations are confidential. Remember, the parties chose arbitration for a reason. And generally speaking, they do not want court records, right? Because again, discovery is very limited in arbitrations, whereas in court, discovery is very large. So you can get all of like their nasty details, and then their public record. So a lot of companies like, no, we don't want to disclose our chip processor or something like that, like how it functions, because then other people would look at the court record and could take advantage of it or whatever. So they don't want court records, right? And theoretically, both sides have agreed, no, we don't want a court record. Even if you never read the contract and you signed it, we assume that you read it, right? So you are bound to it, even if you say, well, I didn't read it. Well, tough crap. Like, you should have. Right? And so that's kind of the look at what the ethics are, what the process looks like. Beyond that, the process of an arbitration looks like a trial, like a traditional trial. In fact, I received from Amazon today, for my arbitrations, more exhibit stickers. Like that, I mean, that's how close to a trial it comes. Now, again, it will be governed by the different rules, what the parties elect, what the parties choose, so on and so forth. But just as a note, it will be similar to a trial. So what I have next for you is a video of a sample of what a arbitration hearing will look like. So we'll play the arbitration hearing. We won't watch the full thing. We will watch a bit of it up until the end of class at 3:10, and at 3:10 we will shut down, and I will send you parts for our first arbitration. And if you've looked at the schedule, I also moved our final arbitration. So there's actually 3 arbitrations we're doing, right? The first one will be the rules of arbitration. You can actually arbitrate the rules of arbitration. So you go to arbitration to determine what the rules of the arbitration are going to be, right? And then you go to the arbitration itself. And we'll talk about this. It has multi-parties, so there'll be lots of interest involved. And then the last one is issue involving divorce, right? How do you approach that, and what do you do? So that being said, we are going to start with this mock arbitration and let you watch it. And if you have any questions, comments, concerns, always feel free to email me. Again, when class time is up, you are free to go.
Good morning, everyone. We'd like to welcome you to Powers Arbitration panel hearing. Thank you for coming in today. Everybody here is in the same business. We're all in real estate professionals. And I'd like to make this as friendly and as amicable as possible. So I would like you to tell the panel how you would like to be addressed this morning. We can address you by your first name, your full name, your title, whatever you would like. I'd like to keep this as informal as possible, so please, starting with the complainant, how should we address you?
You can call me Calvin if you like.
Calvin, very good, sir.
You can call me Mr. Fisher.
Mr. Fisher, attorney at law, counselor, thank you.
Jade is fine with me.
Jade, great.
Amber, it works for me.
Okay, and your witness?
John.
John, very good. Does everyone know where the restrooms are? Okay.
Yes.
They're right outside. Lori's put some refreshments up there, so please feel at home. If anybody doesn't have any questions, I'd like to go live on tape and start the formal process. Anything before we start? Very good. So Juan, please turn the tape on. Thank you very much. I'll now read an opening statement to talk about the policies and procedures of our hearing today. Ladies and gentlemen, I now call this arbitration hearing to order. The Professional Standards Committee is charged with holding appropriate hearings for the Pacific West Association of Realtors in accordance with the procedures set forth in the association's bylaws and the California Code of Ethics and Arbitration Manual. These procedures provide for an arbitration hearing to resolve a dispute arising out of the real estate business. The hearing panel meeting here today is an impartial panel of Professional Standards Committee members who have been selected to ascertain the truth in the particular matter at hand, which is an arbitration hearing, and to render a decision on the testimony and evidence presented. It is to be noted that an arbitration proceeding is to be clearly distinguished from a disciplinary proceeding and should be treated as completely separate matter. The panel before you today has been specially selected by the president of the association based on several criteria, including numerous years of service to the real estate community, ongoing post-license training and real estate education, special training on ethics and arbitration hearing procedures from our association council. The panel is here to ensure that the rules and regulations are adhered to by all members. Now at this time, I'd like to introduce the members of this hearing panel. My name is Paul LePage. I'm the presiding officer this morning. Sitting on my left is Barbara Linhart, and sitting on my right is Linda Eisman. And our alternative today running the tape recorder is Juan Savalas. I now ask that each of you introduce yourself, starting from my left, and indicate your role in today's hearing, please.
My name is Calvin Cooper. I'm the broker owner of Cooper Real Estate.
And you are the complainant,
I'm
sir?
the complaint, yes, sir.
Thank you.
Ronald Fisher, Esquire, attorney for the respondents.
Thank you.
Jade Jones, Jadejones. I am the listing broker for Jones Realty and respondent.
Amber Hearn with Hearn Realty, selling agent and respondent number 2.
John Blue, and I'm a witness.
Thank you, everyone. I want to inform each of you that today's hearing is being recorded. Each of you, when speaking, should identify yourself, and please only one person speak at a time. Parties may purchase a copy of the recording upon written request. You should contact the association staff for the form. No other recording may be made of this hearing. Before we begin and continue on with this hearing, all persons are advised that the proceedings, report, and findings of this panel are considered confidential. All participants in this matter are admonished that failure to keep these proceedings and the resulting decisions confidential is a violation of the National Association of Realtors Code of Ethics and the association's rules and procedures used for arbitrations. Our decision will be available only to the panel members, parties, legal counsel, and staff as disseminated to the parties within the required time period after this hearing is adjourned. This hearing is to arbitrate a dispute arising out of the real estate business. This panel is not a court of law and is not governed by the technical rules of evidence that may apply in court. This panel shall seek to determine all ascertainable and relevant facts pertaining to the matter under consideration, to arrive at a pure judgment and decision that is fair to all the parties. The panel determines its own rules of evidence and its own procedures to be followed to achieve the objectives of equity and due process. The following has been generally accepted and ruled on by this hearing panel as the procedures for this hearing. All parties or their representatives to these proceedings will be allowed a full opportunity to be heard on matters relevant to the issues. The panel may rule at any time during this hearing on the relevance of testimony being given or any questions being directed to any party or his or her representative or to witnesses providing testimony. All parties and witnesses will be asked to swear or to affirm that the testimony given is the truth to the best of their knowledge. A party may be represented by legal counsel. However, no party may refuse to respond directly to requests for information or questions addressed to him or her by the panel members except on grounds of self-incrimination or other grounds which the panel determines appropriate. In this connection, the panel need not accept the statements of counsel as being the statements of his or her client if the hearing panel desires direct testimony. Counsel is present to advise and consult with his or her client and to speak for him or her subject to appropriate rulings or determinations by the panel. This panel will not tolerate any effort by a party or his or her counsel to harass, intimidate, coerce, confuse the panel, witnesses, or any party to the proceedings. The hearing panel may rule at any time on the admissibility of evidence. As the presiding officer, I will act as keeper of the evidence introduced at the hearing and mark each with an exhibit, identification number, and date. The hearing panels are individually authorized to ask questions as they deem pertinent and significant at any time during this hearing. To preserve order, I will rule on questions or testimony by the parties and their representatives or by witnesses in these proceedings. If deemed necessary, I will consult with the panel members and with legal counsel advising this association concerning such rulings. The panel members are not allowed to consider any evidence relating to any alleged violation of the National Association of Realtors Code of Ethics or standards of practice. There has been no adjudication of any allegations. Any allegations relating to the code of ethics or character evidence are not deemed admissible and will be rejected. Any reference to the code of ethics in any of these pleadings will not be considered. So now I'd like to ask everyone at this time, I request that all persons present that expect to testify at this hearing stand and be sworn, or to make the appropriate affirmation in lieu of being sworn. Please stand, folks. Please raise your right hand. Do you swear that the statements you are about to make at this hearing are the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
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 Thank you very much. Please be seated. Now, at this time, I'd like to, Mr. Blue, at this time, be excused from the room, and you'll be called to testify when your party would like to call you. I now ask that the parties, if you have read and understood the outline of procedures for hearing that was furnished to you by Lori, all parties should have been mailed and provided a copy of the outline of procedures for this hearing or arbitration. It's Form A as in apple 8 in front of you. Does any party have any questions at this time regarding the outline of procedure for the hearing? If you do have questions, we'll be glad to answer them at this time. Okay, I see there are no questions, so we'll continue on. Your silence indicates you understand the outline, and we'll proceed with the hearing. We'll let the record reflect that neither party nor their representatives have questions regarding the outline of procedure for the hearing. Could you folks please sign and hand over to me the acknowledgement, please, of the arbitration procedure, Form A9, please? Juan, can you collect that form? Okay, before we proceed with the hearing, I'd like for you to know that the parties are encouraged to settle dispute at any time. The settlement of your dispute is always an option at any time. Anytime during the hearing, you may ask for a recess in an attempt to reach a settlement agreement. The parties, with the assistance of your respective counsel, you can determine the terms of your settlement. The parties should be advised that the arbitration will continue to be processed until formally withdrawn by the complainant. Everyone understand that?
Yes.
Everyone's out in the affirmative. Now, if there are no further questions, I'd like to proceed with the hearing. If there are no further questions at this time, the complainant will make their opening statement. Calvin, please.
Thank you. My name is Calvin Cooper. I'm the broker owner of Cooper Realty, and I'm the procuring cause for 9876 Diamond Drive. Jay Jones was the listing agent. He listed for $1 million, and he was offering 3% through the MLS. And as I said, I am the procuring cause. The actual buyer was Blue Sapphire LLC, and they bought it for $950,000. And I am here today requesting 3% of that amount for a total of $28,500.
Very good. At this time, the respondent, Jay and Amber, please make your opening statement.
Jay Jones, I'm the listing agent and broker owner of Jones Realty. I was a listing agent on that property, and honestly, I have no idea why I'm here. I listed the property, a buyer came, I sold it, we closed escrow, and I have no idea why he thinks that he's owed a commission.
Well, I can piggyback on
Please state your name for the
Sorry.
recorder.
Amber Hearn. I can relate to what Jade is saying. I took a call from a past client. He asked me to show him a property that his company was considering buying, and I showed him the property. They wrote up an offer. I don't know what I did was wrong. That was wrong. what I understand, Mr. Calvin Cooper, if he wasn't so incompetent, he could have sold this property before I ever even became involved. He wrote up 2 offers, and it's no wonder Mr. Opal came to me to get the deal done.
Counselor, do you have anything?
I have no comment, other than we will prove that Mr. Cooper is not owed a dime, 1 dime.
So Calvin, also if you have any new evidence to present to the panel that we don't already have, you're welcome to bring it forth.
Well, I'd like to give you a little background information, but before I do, I kind of resent being called incompetent, so I don't appreciate that. Well, let me give you a little background. I met Mr. Blue, who's one of the 3 partners of Blue Sapphire LLC. His children and my children go to the same school. So there was a gala, a fundraiser, and back in March, and we were talking, and he said he's looking for a property in the Lake Harbor area. Well, I told him I work that area, and I'm a realtor, and if he's not working with anyone, I'd love to show him property. He said, great, give me a call next week. So I called him the following week. We set up a time, and I showed him property every weekend for 3 months. So he didn't like anything out there, there's not much out there, but I've shown him for 3 months every property that was there. Then the end of May comes, and 9876 comes on the market, 9876 Harbor comes on, Diamond Lane comes on the market, and he loves the property. We write up an offer. The first offer we write, the list price is $1 million. We write up an offer for the list price was $1 million. We wrote up an offer for $800,000. That offer was flatly rejected by the seller. So a couple of days later, we wrote up a second offer for $900,000, and that offer was counted at $990,000. And we went back and forth for a couple of weeks, but that deal fell apart. So I spoke to Mr. Blue. I said, what do you want to do? He said, well, let's wait and see if the seller cools off a little bit, lowers the price in the next couple of weeks. He said to give him a call in a month, which I did. So a month later, I checked the MLS, and 9876 Diamond is available. I was happy. I called up Mr. Blue. I said, Mr. Blue, I got some good information for you. Diamond is still available. He said, well, I hate to tell you this, but my company has that property under contract. And I was shocked. Shocked for 2 reasons. First off, it still shows active. And the second reason, I'm your agent. So I asked him, what happened? He said,
Excuse me, can I talk to why I was active?
I thought I have the floor.
Let's let him present his evidence.
Thank you.
Thank you.
So I called him, and he was telling me what happened 2 weeks after the deal fell apart. He spoke to his other 2 partners. There's 3 partners. He's one of them. The other 2 said, well, I know you like the property. You can't afford that much, the $990,000. So the company decided to buy the property. They bought it for $950,000, and they are now leasing it to Mr. Blue. I'm the procuring cause. I think that's quite clear. If it wasn't for me, Mr. Blue would never have seen that property. Now you have the first offer that was flatly rejected by the seller. You also have the second offer that was countered at $990 and that died. And then I also have the MLS printout that shows that the property closed for $950, and that's worth 3%. That's where I get the $28,500. But also, and I'm bringing here today, I have 2 other items. My conversation was...
Excuse me, Mr. Cooper, is this new evidence you're going to introduce now?
Well, I didn't give it to you before, so it must be new.
Well, I object, Mr. Chairman. We've not had an opportunity to review this.
Well, let me tell you what it is.
Just hold on, Mr. Cooper. We've not had an opportunity to review this evidence. It's not fair to my clients and myself, and I want to continue it to 30 days so we have adequate time to review this.
Noted, Counselor. Thank you. I'd like to stop the tape. 1, please.
Oh, excuse me.
Can I tell you what it is?
Question.
Oh, excuse me.
Can I tell you what I'm bringing?
Excuse me. Yes, yeah.
We're going to take a recess anyway to get the copies of your new evidence for all parties.
Can I tell you what the evidence is?
We're off tape, so we're recessed.
Okay.
Also, the respondent stepped out. In this scene, which is the presentation of evidence by the complainant, the complaining party will present new evidence that has not been given to the respondent, and therefore the respondent has had no time to review or to build a defense or to have any line of questioning for the new evidence. This is not allowed by the chair. The normal process will be to stop the hearing, make copies for all parties, and then have all parties given a chance to review. Okay, everyone, we're back from recess, so Juan, please go back live on the tape. Thank you. We were at the complainant was delivering his evidentiary presentation, but first I'd like to cover, everyone please, from this point on, the chair will not tolerate any electronic interruptions, phone calls, etc. Jade, please, don't ever do that at my hearing again.
I apologize.
Okay, thank you very much.
And before we continue, Mr. Chairman, I want to make sure that my objection is on the record to this presentation of new evidence, and that I did request a continuance of 30 days.
Noted, counsel, it's on the recording.
Thank you.
You can purchase from the association for $50 after the hearing. Thank you. Everyone has had a chance to see the complainant's extra evidence. Does anyone have any questions to it? The chair determines it to be admissible at this point. Does the respondent have any input to the admissibility?
Well,
of the
Mr. Chair,
evidence?
may I explain what I've handed out?
Let me get some ascension from the respondent to the evidence first. Do you have any objections to his evidence?
No, no.
Counselor?
I noted my objection.
Thank you. Go forward, please, Mr. Complainant.
Thank you. What I've handed out is a conversation log that I've had with Mr. Blue. It's 2 pages. It starts back in March and ends up in June. So you can see that I've worked with him every
I
weekend.
object, that's hearsay.
This is my conversation log.
It's hearsay.
Next, what I have is my calendar by month of all the activity, the school, gala, when Mr. Blue called me, and when I've shown property each weekend and the number of properties I've seen. Yeah, 1 week I was gone, I was on vacation, but I've showed properties every weekend. And then I have indicated when I wrote the
object,
first
that's
offer.
hearsay as well.
Counselor?
Yeah, I object, it's hearsay as well.
Counselor?
I'd like to continue without interruptions if I could.
Thank you.
So I wrote the first offer on May 30th, the second offer on June 3rd, and then subsequently the property did close on, I have August 12th. And this is just an indication of all the work I put in with Mr. Blue, proving my case that I should get that $28,500. Thank you.
Does the panel have any questions for the complainant?
Not this time.
Not yet. Thank you.
At this time, if there's no questions, the respondent, you can make your presentation of evidence, please.
Jay Jones, as far as my evidence is concerned, well, first can I touch on some points of what he said?
It's your presentation, Jay.
Okay.
Go for it.
First, I'd like to address, he stated that when he called that the property was still active in the MLS. Yes, that is true, it was active in the MLS because we had just finally signed the final counters literally minutes before you called. So that was the reason why it did go back into the MLS as backup immediately after that. As far as he also made a statement saying that the property was leased, does he have any proof that I even had anything to do? Because in our contracts, there was never any talk about a lease. That was never brought up. I don't know if you have anything in writing, so that's something either that you just made up or I don't know what you brought into because I have no idea about a lease. Well, I don't know anything about it. So if you have some, I'd like to see it. And as far as, would you agree that when you did write these offers and you sent me these offers, did I at any time meet you or your client? Do I know what your client looks like?
I don't know what you know, what you don't know.
Okay, well, you stated that I knew him, so I'm just saying, I never met, his client, don't even know what he looks like. And basically, that's where I'm at. I do have my own logs, my own emails and people that signed in here that I consider it as evidence I like, to present as well. Since he presented some evidence, I have my evidence here that emails and everything else that I did through my transaction that I want to present as evidence at this time.
So you'd like to incorporate it into your case?
Yes, I would.
Okay, let's take a break. Juan, please stop the tape. And let's get admin to generate some copies for us, and we'll take a 10-minute recess while we generate copies for everyone. Okay, we're back from recess. Thank you. Everyone is in receipt of Jade and Amber, the respondents' extra evidence. Does anyone have any questions as to the admissibility or how it pertains to our hearing today?
I do, if you don't mind. Jade Barton here with the panelists. Isn't it true that you were notified before this hearing to submit all of your paperwork of evidence and so forth? It looks like quite a pile that you brought in. We're obviously going to have time to absorb and really understand and do this.
Well, we have the same problem that we have here with the complaint and bringing in.
Mine was only
evidence.
2 pages.
If it's going to be wide open, it's wide open.
So just
Ladies and
curious.
gentlemen, please identify yourself for the tape recording before you speak, one person at a time. Thank you.
So once again, my question is, did you not have advance notice to bring all this paperwork in?
James Jones, you know, I did, and after hearing the evidence that he brought in, new evidence, this is actually my notes that I brought in for my recollection. But I think that now listening to new evidence that he brought in, I'd like to bring this in because I feel it's important to my case, and that's why I would like to submit it to evidence. But to answer your question, originally I brought this because it was for my recollection of notes that I took in my transaction.
And Mr. Fisher, attorney for the respondents, if you'd like to continue this, we'd be more than happy to have a 30-day continuance.
Noted, Counselor. Thank you.
Not at this time.
The chair has a question for the complainant. Calvin, was your client ever on a buyer-broker agreement?
No, we didn't have a buyer-broker agreement. I don't work that way. I'm really close with my clients. We don't have to do a buyer-broker agreement.
And that's what he wants to know.
Did you respond? Do you have anyone in the LLC on a buyer-broker agreement?
No.
No.
Thank you. Would you like to continue respondent side with your presentation of evidence?
Jay Jones, I don't even know why I'm here, to be honest with you. I did receive 2 offers that I presented to my seller. The first one was a complete lowball offer, $800,000, we're worth $1 million. We even responded back, tried to respond to him, but he said he was his final, so it didn't go anywhere. Then he submitted another offer for like, I think it was $900,000, and we just couldn't come to an agreement. I never met his clients. I don't know who they are. I did my diligence to sell the property. I later then got a call from Amber saying that she had a client that was very interested in the home. I met them at the home, and it was Amber and 2 other, I guess they're buyers, 2 other gentlemen. I don't know who they are.
Partners.
And I guess partners, and they wrote up an offer. I also like to say that when I received the offers, the original offers from Mr. Cooper, they were not from an LLC. So, you know, I don't know who they were from, you know, as far as who his client was. I had no idea that
My
they
client
were.
was Mr. Blue.
Okay, well, Mr.
Sorry.
Blue wrote
Calvin.
the contract, wrote the offer, but I don't know, there's nothing in the LLC from a Mr. Blue. From what I understand, there was never a name mentioned Mr. Blue while I was there with Amber when they were looking at the property. So I had no idea that it came from the same agent, so I don't even know why I'm here. I think it's a big waste of time for me to even be here.
I have a question, Mr. Chairman. So Jay, you didn't see any similarities in the offers at all as far as pre-qualification information, things like that?
No, I did not. Because when I received everything, it was from Mr. Blue as an individual. And then when I received the offer from Ms. Hearn, it was from an LLC. And it was totally different offer.
Mr. Fisher, counsel for the respondent, the offer from the LLC was all cash. There was no financing involved.
Okay. Were you another question for you. Were you present during any of these showings?
Yes, the presence with Ms. Amber's clients,
Okay.
not with Mr. Cooper.
Okay, all right, thank you.
Not at this time.
Respondent side, would you like to call your witness at this time?
Yeah, I'd like to say a few things first.
Amber, please.
I'm sorry, Amber Hearn from Hearn Realty. Okay, when Mr. Cooper says that he's a procuring cause because we wouldn't have known, or the clients wouldn't have known about this property if it wasn't for him, I dispute that because with everything on the internet nowadays, the public has access to this information. There is no reason to think that if it wasn't for Mr. Cooper introducing Mr. Blue to this property, that they would never have known about it. I mean, they could have driven down the street and saw the sign. So there's no procuring cause as far as that goes. Okay, so now I would like to call my witness.
Can I ask one question before
Sure.
that? Was there any familiarity when they first contacted you? In other words, when I say familiarity, how much information did they know about the property, or did they give you any other information at all?
Well, Mr. Opal said that one of his partners brought up this property because he had seen it or known about it, and I don't think there was an undue amount of familiarity with it. I did not get the impression that they had seen it or had any undue familiarity.
And one other question, when they contacted you, was this the only property they wanted to see?
Yes.
Thank you.
Jade, I'd like to also add that during the time that we were in escrow, never once did I see a Mr. Blue come to any of the inspections, or at any time did I even meet him. So, you know, for him to say that it's his client that bought the property, again, I dealt with a completely new agent and a completely new buyer, that regardless if they know each other or whatever relationship they have, the person that wrote the offer that my seller accepted came from a different agent. It was a cash offer, way different than his offer, which was financing, and it came from an LLC. And never one time did I meet his client that wrote the offer or was at the property. He said something about that it was leased. That was never brought up in our listing and in our contract and while we were in escrow, I should say. So I don't know where he came from that.
Thank you.
Calvin Cooper, I'd like to respond to what was said before. I am the procuring cause because I have the MLS computer set up. It didn't hit the internet. What happens, it was automatically sent to me on, it came on the market May 27th. I was notified the same day. I got Mr. Blue out there the same day, and we wrote up an offer immediately. So don't tell me it hit the internet and he found it another way, because that's not true.
What I said is that he had access to the information.
He found it through me.
Amber?
He found it through me.
Amber Hearn. He had access to the information through the internet. It was
had
on the market long enough for it to hit the internet and for him to find it there and decide that he wanted to purchase it.
He found out through me because it came on I was notified through the MLS, and I called him immediately, and we got out there.
Well, this is Mr. Fisher, the attorney. You say you have a close relationship with your clients. That's one of
Our
the,
children go to school together.
yeah, so, and you met him back in March. So
Well, that was
known
when
him
the
for 2
gala
months,
happened.
right, but you knew him for about 2 months. And you had such a close relationship with Mr. Blue that you knew he couldn't afford this house. That's why you wrote the $800,000 offer. You
Well, that's
knew
not
he
true.
You knew he didn't have the ability
Don't tell me what
to
I
make
knew.
payments.
Don't tell me what I knew.
Oh, yes, no, you knew
No,
that.
800,000 was his figure, not mine. And in fact, the second offer was 900,000. And yes, he had to get financing, and he's pre-approved.
You sure you pre-approved him?
Yes, I got him pre-approved. I got the letter.
For
It's
how
new
much?
evidence. Would you like to see new evidence? I have the letter. I didn't
Yes,
bring it
I'd like
with
to
me.
see that.
I didn't bring a pre-approval
Oh, here
letter
we
with
go
me.
again. New evidence,
Okay, gentlemen.
no evidence.
Gentlemen?
Jay Jones, I'd just like to add, do you really think that by writing 2 offers that were lowball offers, where they weren't even close to being accepted, that you've earned yourself a commission by writing 2 bogus offers? Everybody would be wanting a commission if that was the case. You didn't do anything. You wrote 2 offers that didn't go anywhere. How do you figure, you can ask him, how does he figure he's owed $28,500, which you keep saying, for doing absolutely nothing? You should have really done your homework and wrote a buyer-broker agreement and done what you're supposed to do, and you didn't do that.
All right, so what I'm gonna do is I'm gonna stop there, but you can kind of see where things head. And if you want to, you can watch this full video. From there, they do call witnesses, and you can see that like everybody gets a chance to question witnesses. But you see, it feels kind of like a trial, but there's definitely a lot more back and forth than there would be in a formal trial. right? Because it's not a trial, it's an arbitration. And really, the parties have as much leash as the arbitrator gives them and as the rules give them. So that's why it's really important that if you ever come across an arbitration clause and it says it's governed by the rules of the AAA, that you read through the rules of the AAA before you decide, yes, I agree to this arbitration clause, or no, I don't. So that being said, I will send out parts later today. And for the first one, I will be the arbitrator, and I have an idea for who's going to be arbitrator in the second, the divorce proceedings. So yeah, just be on the lookout for that. And beyond that, have a good day. And as always, if you have questions, feel free to email me.